So, everybody, we are back today with Mr. Brett Woodburn. Brett, how are you?
Doing well, Nick. How are you?
I'm great. Thanks for asking. So, today we're going to take a little bit deeper of a dive into a very untalked about topic that people don't think about. And that is what it needs or what you need when you're dealing with selling a property that's in a trust where you have POA, estate, and what you do with all the deed for all three, and title work and all that fun stuff. So, out of the three, Brett, which would you say is the most difficult and the most easiest to deal with?
I would say that probably the one that trips people up the most is the power of attorney. Believe it or not, because uh, and this is funny because it's been many months, probably over a year or so, since I've really had any transactions with powers of attorney. They long period of time with nothing going on, and now I've had several. And people like to, even non-realtors like to practice law without a license, and they use this evil device called a computer that goes out into the world of chaos and mayhem called the internet. And then they use these things like artificial intelligence, with the emphasis on artificial, to create a legal document that is non-compliant with Pennsylvania law. Uh, or they have a document that's been around a long time, and they've got a photocopy after a photocopy, and copy stains, and maybe there's pages missing, and the consumer says, I got I'm power of attorney. And the realtor goes about their business without doing any type of without understanding what that means and what's required when we get to closing. So probably the most important thing, I wouldn't expect a realtor to be able to look at a power of attorney and say, oh, this is compliant with Pennsylvania law or not. That's
Right.
not within your wheelhouse at all. Although I would tell you that if you've got somebody that's going to do a transaction through a power of attorney, get it to the title company sooner than later so that they can look at it and make sure, um, because there are some requirements that need to be on there. And if it's an out of state power of attorney, get it faster, because title company is going to need to run it through underwriting counsel to make sure that it's compliant. And sometimes we got to check with an attorney from another state to make sure that
Yeah.
it's compliant within their state. But what I think as a realtor you need to appreciate and understand is the title company needs the original power of attorney in order to record the deed. And I've had realtors say, oh, I work with this person all the time and I've got copies of everything. Great, I need the original. What do you mean you need the original? Can't you just make a copy of it? Well, what county are we in? If we're in Dauphin County, if we're in Cumberland County, I mean, I want to see, as the title agent, I want to see the original, because I want to see that it is a legitimate document, not just a copy of a document, because it makes me a little bit nervous. But I typically would scan in the original and then record electronically. But for example, I have a closing coming up in a couple of weeks in Snyder County, and Snyder County does not electronically record. It is the son of elderly parents, and he has two valid powers of attorney, one for mom, one for dad. And the agent is listing it. Well, we're just we'll sign everything remotely. Well, no, I need you to come down here because I need the original. Well, we'll scan it to you. No, literally need the original, because I have to mail it to the courthouse. The courthouse has to record it and then mail it back to me. And that is
Yeah.
a period of time. If you're in Adams County, is another county that doesn't do electronic recordings. It's somewhat local to, actually probably geographically further than Snyder County, but you need to understand, or you want to understand, what the county requires, because your person will be without their power of attorney for a period of time if we have to mail it away. It might be days, it might be weeks, and there's nothing that we can do about that. So A lot of what you have to do as a realtor, once you're through the negotiating process, or even through the whole by the time you start meeting with them, is set expectations and set them realistically. And what would you look at? The most important thing what you can look at as a realtor. I have a power of attorney. All right, without looking at to see whether or not it's compliant with Pennsylvania law. Is it signed? Is it notarized? Is it witnessed? And does it give the person the ability to transact real estate? You can look at that. That's not a legal conclusion, because when I read it, it says I can sell real estate, or it doesn't say anything about real estate. So if it
Yeah.
doesn't say anything about real estate, then you don't have the authority.
So, Brett, you talked about the AI systems that are out there, but there's other systems that are also out there that, anybody with Google can go look and they can find these, hey, pay this monthly fee and have access to all these legal documents. What if somebody does one from that? What do you feel that the liability, and who is the liability on if they do not have what needs to be done? And let's say you go under an agreement of sale and then it comes out like, oh, this isn't a power of attorney that can be used.
Here's your favorite phrase, right? It depends, and what it does, it really depends on how the transaction evolves. Okay. And what's the liability at the core? Who's responsible? Probably the seller, because they're the one that's putting it together. And I say probably because I I can't tell you, there are sellers that have said, well, my realtor told me to go to this website and download it and then it'll be fine. Okay. Maybe they did, maybe they didn't, but I've been doing this long enough. And as you know, I don't make up any of the stories that I tell. I just change the names to protect the idiots. I mean, the innocents. Um, you can edit that out, I think. Anyway,
No,
or
I
not.
love it.
Yeah. Um, so, or if, I guess where your exposure as a listing agent would be, if the seller is going to be using a power of attorney, if you don't do any diligence, any of your own due diligence as a professional. All right, let me take a look at it up front. You don't need to bring me the original right at the beginning of the transaction, because I know, and as you did, so many things can go wrong in the transaction. But hey, we're under agreement, we're going through inspections. Copy it and send me a copy so I can look at it. I might need the original, but I can look at it pretty quickly and say, yeah, it'll work, or I got some concerns about this. For example, in Pennsylvania, there is a very specific notice page. The law was amended back in, I don't know, 2018, 2019, 2020. And they added a very specific, and the language is proscribed by statute. So it has to be a certain thing in a certain font. And it's telling the person who's granting the authority that, hey, you're giving up your legal right. You're giving someone else the legal right to act on your behalf, and they have to sign it and date it. And I had a power of attorney that came in earlier this month, and it didn't have a notice on it. And I'm like, that's not a Pennsylvania compliant power of attorney. And they went and they pulled out another form. They said, well, how's this? The bank put this together for me. You're using a bank in Arizona and you're in Pennsylvania, so it's just
And as you know, banks have separate power of attorneys for things that they use.
correct.
Like,
Correct. So you could, as the listing agent, get yourself into a little bit of a mess by not acting in your fiduciary capacity, right? Your responsibility is to put your client's interests first and make sure you're doing the right things. Hey, they're operating on a power of attorney. Let's get the okay right away, because um, we need to have time if we need to fix it.
yeah.
Can this be fixed? And just, we'll just go get another power of attorney. Well, what happens if the person who granted the power of attorney is incompetent and they can't fix it? Then we have a different problem,
We have a whole different problem.
and that's not going to be fixed in a couple of days.
No. So Brett, Sally dies. I have power of attorney for Sally. I'm still good to go, right?
Sure, right to jail, right to realtor jail. Now, the power of attorney is immediately revoked upon death of the grantor, um, and I would advise strongly, not legal advice, but strongly, good, smart advice. If your client asks you to accept the power of attorney so that you can sign documents for them, say no.
Oh, well,
Uh,
I was just meaning me as like an individual selling, like, say, my in-laws' house. I wasn't meaning me as the agent. So yeah, I guess I should
no,
have rephrased
I've
that.
had buyers, I've had buyers agents and listing agents where their client has granted them the power of attorney to act on their behalf.
That's bad because you have a financial interest in doing it. Like you're getting paid out of it, and now you think you're not going to get called out for like, oh, did you actually do the right thing? Like, oh
Right.
Jesus Christ! Then
It just,
I shouldn't
and
be
it's,
surprised.
and it's painful, right? Because of, so you would, if you were my power of attorney at going to closing, you would be writing down, you would be signing Nicholas Feagley, attorney in fact for Brett M. Woodburn, every time you sign your name.
Oh,
And
I
that's what it,
barely like signing my name agent
yes,
for.
yes. And and it is, it would be Nicholas Feagley, attorney in fact for Brett M. Woodburn,
No,
every time you sign.
yeah,
And
no, that's
if
never
we're dealing
happening.
with a first time home buyer,
Oh God.
and you've got the second, like for example, the Dauphin County assistance, down payment assistance. So you've got two loan packages, and you're so yeah. So don't do that. That's I think is asking for a headache on a lot of different levels. I don't think you're furthering your client's interest to do that. I think you're taking on
You're taking on liability that
you're
you
not getting
just don't want
paid
to
to
take.
do
Yeah,
that. You're getting paid to
it's not worth
help
it.
them buy a house or help them sell a house, not to go in into debt over the house.
Yeah, yeah.
So those are the big things that I've seen. And again, it's always the important thing is remind them, when you're the listing agent, where else could you get yourself into a pickle is, not reaching out to the title company soon enough, not only to find out is it compliant, but also, are you going to need to send the original away? Or are you able to record it electronically with a copy?
Yeah.
Uh, because you need to set your client's expectations on what's going to happen.
Yeah, for sure. So here's a question. How often is it that there's more than one power of attorney, even though it all says the same thing? It's all to the same person, but there's more than one original recorded or done in situations like this, like with death certificates. You get like 12 of them, and you get one or two of the short certificate. Like you get multiple because like everybody's going to want a copy. Can you do the same with power of attorneys?
And I've seen instances, and I've got colleagues of mine that have done it where they're preparing two or even three. And like, for example, if they're preparing three, they're keeping one original at their office or in their safe. And then they're giving the other two so that if I've got to submit one for recording and it's out of my hands for a while, I've got another one in case I need to do something, which is important if you're if you're acting as attorney, in fact, for somebody that is disabled, that has incompetence, that is unable to replace it. You want to have that safeguard. It's a smart thing to do. Um, and people lose them. I mean, that's a fact of life. People will lose them. And if you don't have the original and the person is no longer competent to replace it, then you've got a
There's
different scenario
you've
you
got
have to deal with.
which we won't get into that one today because that one's definitely much more complicated.
Correct.
All right, so here's the situation for you, and this will kind of lead us right into the next topic too. So, I have power of attorney for my father-in-law. We're selling his house. We are under contract, and I'm not his agent. Let's say this is, I'm not licensed in PA, and we are 2 weeks in, and he dies. What can you and what shouldn't you do?
So this is interesting because the PAR agreement has the provision in there that says binding on heirs, executors, and assigns. Um, but I wonder what happens if the person who's died, if they have a will and the will gifts the house to one of their beneficiaries. What's the consequence of that? Which takes priority? There's a potential legal issue with that. Um, what I can tell you is the agreement of sale as it sits isn't going to work because the person who owned, past tense, the house is not able to sign because they're dead, and you're not able to sign because your authority to sign on their behalf died with them. Now, are you the executor of the will? At that point, you go to an attorney.
Let's say I
Probate.
am, to make it easy.
Okay, so now you're the executor of the will. Now you can, and let's assume, for point of simplicity, that it still makes sense. There's nobody that's getting the will as part of the direct inheritance. You're able to go forward with the transaction. There has been some delay because between the death and the issue and appointment of you as the
That can take
actual
time.
you as the executor, the granting of the letters, of death certificates, et cetera, it's going to take a few weeks. So now we're longer out there. You also can't. You've got to change the agreement of sale.
Mm-hmm.
And I mean, we can do it the right way, or we can do it the realtor way. The realtor way is we just simply swap out the first page and put in the new seller and pretend that old first page never existed. Or what we do
Which
is
is not what we do, people.
it is what you do. It's just not the right way to do it. Not what you do, Nick. Or the
I
other
was
way to
gonna
do it.
say.
Yeah. Or the other way to do it is, I mean, a lawyer would probably want to redraft the agreement and adjusted the timelines and everything accordingly. Because who's the seller now?
Technically, the person who's acting as the executor is the seller.
Great. So this was a bit of a setup for your listeners because you and I have talked about this, so you know the answer. The seller is not the estate of John Smith. The estate has no
Sally
fingers to
Smith,
hold the pen
executor.
with. So it would be Nicholas Feagley, executor for the estate of John Smith, by the way,
Yep.
which is how you have to sign the deed. And you have to be named the executor in order to have that authority. And so that's what happens with respect to who the seller is. But
So, yeah.
go with your
Okay.
question, then I'll go with my add-on.
So let's say, though, in that time frame, because now we have to wait almost a month till death certificates here, short certificates here, I'm named, I'm able to start signing things, but there was only 2 weeks left in the contract. Nobody can sign for the extension at that point in time. Nobody on the seller side can even terminate because nobody's legally allowed to sign. So what do? Just let it sit in limbo?
Well, this is where where the magical powers that come with being realtors really help make a transaction work. All right, you've got the Lazarus power. Okay, so that once the settlements comes and goes and the agreement dies, you guys just simply do an addendum and bring it back to life. Uh, and it drives lawyers nuts. And when I teach it, lawyers, they just, they have canaries about this, but the practical answer is it works, which is why a lawyer wants a whole new agreement, right? Because it really is a new contract because you've got a whole new seller. And from the lawyer's perspective, I am one. I didn't just sleep in a Holiday Inn last night. I actually am a lawyer. I understand the
The
legal
thought process.
rationale. I do. It makes a lot of sense. But for good or for ill, I've spent 25 plus years representing realtors. So my mind has been frayed with the realtor mind meld that goes on. So I understand the realtor thought process as well. Hey, it works. And honestly,
If it's not broke.
and if it is broke, we'll just do an addendum, and it's going to be fine. Um, and then there's a legal principle that if you do that and you act in further and sub it, then you're stopped from denying it at a later point in time. So
Yeah, there's that too.
the vast majority of the time, even though you don't necessarily do it the way the law
Intentionally.
wants you to do it, it doesn't necessarily invalidate what you did. And if it works out the way everybody wanted to work out, okay, great.
I know, but it's always that one person.
If it goes bad, it can go colossally bad.
Right.
Yeah.
So, in this situation, yeah, you could let the contract just roll because technically, as long as the closing date went and buyers are not causing an issue and seller obviously can't cause an issue, they're dead. You can let it go and do a change in terms, or just write a whole new contract at the end once the executor is named, fixing and doing everything that needs to be done, and then literally probably most likely be able to close in the next week once the title company reviews everything for the estate, gets all of that, because then you got to have the conversation around the inheritance tax and all that fun stuff. Like, so it's probably not going to be like next day as soon as you have the estate documents. It's probably going to be a
No,
week.
it's going to be a little while because, yeah, a little while. And I'm gonna lawyer respond to your just let it ride to a CTA. That's probably a practical way that will work. That's not the way the lawyer will tell you, including me, not the way I will tell you to do it.
But technically, who can terminate that though?
Well, so I mean, I would say that once settlement comes and goes, the contract dies based on its terms.
Okay, so then release the deposit back to the
And now
buyer.
you're right. Now your question is, did the seller breach? Well, I'm not sure that death is a breach. I
It's
think it would
not.
fall.
I don't think so.
I think it would fall under impossibility of performance. And then you've got, well, the heirs, executors, and assigns. Okay, but you didn't have anybody who could sign for the estate before the contract ended.
Expired.
So, and this is where again I come back to where I started with this part of the conversation. The realtor's practical approach to handling it usually makes it work. I mean, frankly, if the buyer still wants to buy and they're able to wait until this gets to the point where they can sell, and the seller still, the executor of the estate is still willing to sell to them, you work it out and you make it work, which is probably the vast, vast, vast majority of the transactions.
Yeah.
Where it becomes problematic is if there's a specific bequest where the house is being willed to somebody, that creates an issue. I've seen situations where it has been one of the buyer's spouse, one of the spouses dies, and situation where the seller's like, heirs, executors, and assigns, you still got to buy it, and you're trying to hold this young. It was in that situation. I don't even know if the couple were in their 30s yet when the husband, home on leave from the military, lost control of the motorcycle, or as my brother, the doctor, says, a donor cycle. And the seller initially took the position that they were going to try to force the widow, the pregnant widow, to go to closing. And at the end result, when the attorney got involved, fortunately, I think for everybody involved, the attorney was a practically minded, wasn't me, but a practically minded attorney who looked at it and said, okay, go to your lender and find out if you can qualify for the loan. And the lender denied because
She can.
she
Yep.
couldn't. And
Yep.
then she got out, and so
I don't even know why an attorney had to get involved in that one. A
because of
barely
the
competent
deposit
realtor
money,
should have been able to. Yeah, but a barely competent agent should have been able to figure that
seller
one
was
out.
on that one. The seller really was digging their heels in. That was actually a seller driven problem. The seller was just
Ugh,
that person. you
God,
know,
I hate people.
yeah. So
So
yeah,
that
but
leads us right into,
yeah,
what do we need for an estate? What do we need documentation wise
you need the
to do
will.
this?
You need the will.
Okay.
We need to have, because the title company needs to see the will. The title company needs to see that how is the real estate available to be sold by the executrix, or is it going to one of the heirs? And if it's going to one of the heirs, does the heir not want it? And is that why it's being sold? So do we need to get them to disclaim their interest? Do we need to get them to sign off on the deed? I've seen wills where the house has been willed to the three kids who no longer live anywhere close to this house and don't want it. And now you got to get a deed to three people in different parts of the country. And so get the will. You're going to need death certificate or death certificates. And what if your seller is the surviving spouse, and their spouse died a year ago, 2 years ago, 5 years ago? You might need to get a
Still be
copy of
living.
their death certificate, because most people don't transfer
Remove.
title if they own it as spouses, husband and wife, husband and husband, wife and wife, and one dies. They don't transfer from into their own name individually, and so when they go to sell or their estate goes to sell, we need to prove that both people are deceased.
Yeah.
And that could take a minute to get the death certificate.
Okay, so because I've dealt
There's
with a
another
good bit of
aspect to this before you switch off of estates. So if you got an
oh,
estate
I'm still
question,
on it. I'm
okay, go
still
ahead.
on it. So I've dealt with a good bit of estates on the sell side, on the list side. So who has the liability if, all right, so I've never, in the probably 10 estates I've done over my career, have I ever been asked to provide a copy of the will. I've only been asked for death certificate and short certificate. So who, in your professional opinion, although this is not, who has the liability if there was somebody that had rights to the property? Stop lead providers from auctioning off the buyer leads generated from your listings. Meet InstaShow Plus, a premier showing management system built to generate, qualify, and convert buyer leads for you. Agents receive verified leads, and you never meet unqualified or unidentified prospects. Take control of your leads and your safety today. Learn more by emailing us at hello@instashowplus.com. That's hello at INSTASHOWPLUS.com or call us at 877-877-8030.
Transform your property with DB360 soft washing. Say goodbye to dirt, grime, and stains with DB360 soft washing, the experts in safe, effective, and exterior cleaning. We specialize in soft washing, roofing, siding, driveways, walkways, decks, fences, commercial and residential, eco-friendly solutions, and insured. Call us today at 717-691-1712 or visit us at db360wash.com. DB360 soft washing, clean you can trust.
Need a handyman? Call the Handyman Guy, LLC. For small fixes to major projects, call the Handyman LLC. Deliver professional, reliable, affordable services. Our experiences: repairs, painting, plumbing, electrical, carpentry, furniture assembly, and much, much more. Licensed, insured, and definitely quality guaranteed. Call our number, 717-819-5453. Visit us at thathandymanguy.com. The Handyman Guy LLC, your trusted home fix expert. Thank you. Have a great day.
So if it's a probated estate, I'm probably going to get the will through. I'm probably going to get it through the search. Title search will find it probably through the orphans court and get a copy of it. Or if there's an attorney involved representing the estate, they'll provide a copy of it. Title companies need copies of the wills. Everybody that understands their business knows that.
Okay.
I said it that way for a reason.
I know. I just started panicking because I'm like, I've never been asked to get that for the title companies.
You may not be.
Okay.
I don't.
Phew.
Yeah, I'm usually getting it from. Sometimes I'll get it. It depends. So I do know there are some realtors that are oftentimes appointed or involved in these types of transactions, and they just get them together as a matter of course. They know they're going to need the short sale, the short certificate. They're going to need to get the will. They're going to need to get this, that, and the other thing. Title company's going to ask for it. Let's get it all together. They just do it all the time, and they're providing it when they're sending the information over to the title company. We're getting it probably most of the time. I'm either getting it in the search. I'm probably getting it in the search most of the time, and that's fine because it's recorded and I'm seeing what it is. And then I can figure out what else do I need to know, or what else other information do I need to get. You need, depending on where you are in the process, the estate is, not you in the transaction, but where the estate is, you want to, if you're listing the property, you want to prepare your seller for an escrow, a holdback, because the title company, after the inheritance taxes are paid to Department of Revenue, once revenue reviews the returns and says everything is good to go, they will issue a notice of appraisement and acceptance, which is then recorded. And they says right on there that you don't owe anything, or there was a refund, or whatever the case may be. Until that's filed by revenue, until that's issued by revenue and filed, title company,
holding money.
we're going to hold the money, because revenue, probably 10 or 15 years ago, revenue started taking the position that inheritance tax was due as of the date of death. So if there's an unpaid tax, it relates back to the date of death, which means it's a pre-sale, pre-closing debt, which means it's a title claim that falls to the title insurance company. Whereas previously to that, revenue never took that position, and the title industry said, oh, well, the taxes weren't due until after the estate was done. The estate may not have been done until after the house was sold. It's a post-closing event. And revenue says, now it relates back to the date of death. So now, and title is going to hold 1.5 times what the inheritance tax is
on
for
the
the
sale.
property, on the sale.
Mm-hmm.
Right. And that's the starting point. Are there ever times when title holds less? Yes. It takes underwriter approval. And to do that, underwriters going to want to see information about the estate. Like, for example, we filed the attorney files in a preliminary return, and they paid, a big chunk of money to the estate, and there's not a lot of money left. And can we reduce that? All right, give me the data. Let me see where it is. I'll send it to underwriting counsel and see what they say. And a lot of times they'll say, yeah, it depends on how much is in the estate.
I've actually seen them waive it too.
Occasionally.
On one that they already paid in like $99,000.
Yeah.
They're like, yeah, you're good.
Yeah, it happens sometimes. But that penalty on a claim is gotten a little bit more. They're harder to get them to clear it.
Yeah.
Any more than that. The other thing to think about. So Nick, when you're as an agent, as a buyer's agent, all right, generically, don't in any kind of a sale, what type of deed are you getting?
So in any type of sale,
regular sale,
you're getting a special warranty deed.
Correct. So
you're not with an estate, though.
Maybe.
I've not seen one with an estate yet.
Most of the ones that we close end up with special warranty deeds.
Oh, I haven't seen that.
Yeah, and that's based on whoever's preparing the deed.
Okay. So Brooks and Rescom do special warranty deeds. We'll do a little plug there.
Look, when I get if I'm looking at it, what's the agreement of sale say? Special warranty deed. Okay, so what happens in your scenario? The seller dies mid-transaction. What if the executor is an attorney or a bank, and they may refuse to give you a special warranty deed because a special warranty deed is from the seller saying that any debts that were attached to the property during my period of ownership, we're going to warrant, and that's title insurance covers that, so the exposure's not what it once was. But the bank's going to say no. A lawyer will say no. We'll give you a fiduciary deed, and a fiduciary deed provides no warranty of title. Do you care as a buyer? Well, if you're getting an owner's policy of title insurance, probably not, or not too much. It's a pretty, because of the way title insurance works. If you get the owner's policy, the warranty, that special warranty, is less impactful in real life. But you have to recognize that, because if the estate is the seller, okay, you're listing it as the listing agent, the seller, we've got the executor that signed off on this. As a listing agent, you should be asking the question, what are we offering? Are we giving a special warranty deed, or are we giving a fiduciary deed? I've seen them also called executor's deed, but it's really a fiduciary deed, the same thing. What are you giving? And so when you get the agreement of sale, the offer in from the buyer, go change that. And, it says you're giving a special warranty deed unless otherwise stated here, and so, no, we're not giving a special warranty. It's a fiduciary deed. And I think as a listing agent, I think that does fall in your responsibility, because It's your responsibility to know the agreement of sale and what you're offering, and you're the one negotiating it. So, that is not legal advice. That is know your tools.
You know I love my buttons.
You do, and more importantly than loving your buttons, you love pushing them.
I do.
Yes.
Interesting. So I've learned something. I'm going to start asking for the will up front just so that I can provide it, because you know me, I like to provide as much as I can to make everybody's life easy. So
And a
just give it
copy
to
of the
me.
will is fine.
Yeah.
It doesn't need to be an original.
Yeah.
It doesn't even need to be a certified copy.
Just a copy, because
Just
you
a
guys are
copy.
going to pull it anyways. But
Correct.
at least then you'll have it. You can probably pre-see issues before you even get it in and be like, hold on, we got something to clean up.
Yeah, it's
I don't like
quick read
surprises.
for you as the agent to look at it and say, yeah, it clearly states in paragraph 3 that you have the power to sell real estate. And as I flip through here, I don't see anyone giving this particular property to somebody else. Not that if you saw that, I would expect you to solve that problem, but that would be one where you say to the title company, hey,
We have an issue.
look at this to see if we have an issue. Yeah.
Okay. So.
And it's similar with the trust.
I was going to say, so
Yeah.
now we add the whole level of a trust.
Mm-hmm. And in a lot of ways, there's not, other than how they come into existence, one typically when someone's alive and the other when you die, but the way that they're processed, the way that they're reviewed, the way that they're considered, certainly from a title perspective, and I think from a realtor's perspective, very similar. Very similar. You're not, if I've got the Brett M. Woodburn Revocable Living Trust of July 24, 2024. Well, I'm the settlor and the trustee. Well, that would be Brett Woodburn, trustee for the Revocable Living Trust. It is the trustee that has the authority to act on behalf of the trust. So, again, you don't list a property for sale by the Revocable Living Trust of Brett M. Woodburn might own the property, but it can't sell it. But the trustee sells it. And again, you want to look at the trust. The title company's going to want to look at the trust or a certificate, depending on where what state is from. You may not get the trust, or there may be confidentiality purposes. I've seen some trusts that have come through from over the years from some very, very recognizable names, whether it be in the sporting world or in the entertainment world, and they won't release the full trust. So okay, but we need to see certain certificates that represent to us that it has this authority.
Yeah, because when you look at a trust, isn't the point of a trust to protect who the beneficiary is?
Correct.
So, in my opinion, handing over all the documents is no longer protecting who the beneficiary is. This may or may not be a way that people like to hide things, but
it depends on the complexity of the trust, right? Because because like a lot of stuff, it's I need to see his title. I need to see that the trustee has the authority to sell the real estate. I need to see that the real estate is an asset that can be sold. And the easiest way, and overwhelmingly, I mean, the highest percentage, 97% of the time, I get a copy of the trust documents. I mean, I'm not giving them to anybody. I mean, there's a certain obligation that I have to keep the information. So I'm getting it that way most of the time. Every now and then you'll get something. It's like, okay, let me talk to counsel. Let me talk to the trustee. This is what I need, and this is what will work. For example, California, their laws protect the privacy of the testators, the people that make the trust documents themselves, and it's against the law to require the trust to be provided. But there's certain, I'm going to call it a memorandum of the trust, for lack of a better word, a summary of what's in there that identifies the authority of the trustee to transact. And if there's a specific question about the particular property, I can ask for an affidavit, and the law gives me the ability to rely on that affidavit as a title agent, not just as an attorney, but as a title agent. So again, knowing ahead of time that we got the biggest frustration is finding out the day, the day before that it's a trust, or because that may not be recorded. I'll find that out when I get the title search in, because the deed will say it's held in trust. Or the same thing if I'm buying the property and I want it to go into my trust. Well, hang on. We can't do that the day of, because I need to see that the trust actually exists.
So, Brett, what's it cost to have a title search done?
For a residential property, you're typically looking between $165 and $250, depending on the copy work that's involved, right? Because there's where the cost really comes in. If you've got somebody that's got your abstractor goes and makes copies. If the property's been sold many times and there's a lot of people in the chain, or if you've got an association, like for example, Deer Run in Hummelstown, because they're recorded documents, conditions, covenants, restrictions, and all the amendments. I don't know if they're up to 32, whatever it is. I mean, it's a stack of documents. I mean, you're talking probably, if you'd print everything out two-sided, it's probably a ream and a half of paper. So something like that, you're going to be probably closer to $300, $400, depending on the cost per page. So that's the biggest variable, is the copy work. But to get a search done, and it's, again, the fair price. If you expect to pay between $165 and $250, that'll probably cover 85% of your searches.
And honestly, I don't think that's bad for a seller to just go, hey, look, let's get it done ahead of time. Let's know anything that we're going to need to know, especially with an estate, maybe with a trust that, maybe the trustee didn't know what was done. Maybe they were newly appointed or whatever. It doesn't hurt to just get that done ahead of time with your listing agents, go to title company, because I'm sure they'll do it, and just pull it so that you can see. I mean, you know me, I don't like surprises. I said to a set of clients today, I said, I'm a part-time firefighter. And they both looked at me. I said, because I'm constantly putting out fires that clients cause me. Like, I think they actually thought like I went and put out real fires.
They clearly don't know you. Yeah. And I think that's, of all the things that a seller could do, that wouldn't be in my top 5. I think that I think one of the best things a seller can do is a pre-listing inspection.
Yes.
Now, from a buyer's perspective, though, realtors like to hold title until the inspections are done.
I hate that. I fucking hate that.
And probably one of the most underused contingencies in the whole agreement of sale is deeds, use, and zoning, right?
Yep.
And, because here, I don't want to devolve too far into the title conversation, but the whole purpose of title insurance is to ensure your ownership, not your use. So when you buy a property and the next door neighbor's septic tank is in your backyard because there's an easement allowing that to happen, you don't have clouded title. I mean, you've got it. You're taking subject to, it's a recorded easement, and title is saying you own it, but you don't. But they have a right to it. I wouldn't call it a cloud on title, but some people might call it a cloud on title. It's just someone else has a claim to that property, and I want to sue the title company for doing what? Well, I can't put a pool in the backyard. There's a septic tank in there. That's not what title company is for. Hey, just you own what you thought you owned. You just can't do with it what you thought you wanted to do with it.
Yep, and that's different.
Yes, very different.
Yeah. So let's talk about deeds. How to take deeds, why to take deeds in a certain way. Obviously, everybody needs to have these conversations with their powers that be. This is not, I just put it up there. So, let's say Kelly and I bought our property. We took our deed, and I'm pretty sure this is the route we were taking this. We took our deed as tenants in common. Or no, we took our deed as tenants with rights of survivorship.
Joint tenants with rights of survivorship, Or were you married when you bought it?
Oh, don't do that to me.
Well, I'll throw you a
Oh,
life preserver. If you took it, if you were married when you bought the house, you probably took it as tenants by the entireties. If you
no.
if you bought the house before you were married, then joint tenants with rights of survivorship.
So no, I don't think we were married when we bought the property. Oh, I'm being told we were. Oh, yeah, we were married when we
So
bought the
Nick's got to
property,
make up
Brett.
some ground this weekend with his husband. You now match your sweatshirt.
So yeah, never mind, we were. All right, so let's talk about those differences. Let's talk about, and this is where we were headed with this, right? I thought so. We were on the same wavelength. So let's talk about the marriage way of the rights of survivorship to the other route, and then there's still other routes that we can take this. So with
There's
tenants,
basically three ways you can take title. You can take it as I mean, if you're say four, right? Individually, my own name as a sole owner. I can take title with someone else as tenants in common. I can take title with someone else as joint tenants with rights of survivorship, or I can take title with my spouse as tenants by the entireties. And by the entireties is only available if you're married. You cannot take tenants by the entireties if you're not. And
and
what's
what do each do?
okay. Yeah. So first of all, what's the difference between joint tenants with right of survivorship and tenants by the entireties? Trying to figure out how to spell entireties. One is you're married, one is you're not. I mean, beyond that, they both function the same way. If you're taking so if you think of the idea, and remember, Pennsylvania historically it started as a Quaker state, and that is not the place where you go and get wings. It's not the oil you put in your car. It was an actual religion, and the concept, when two people become married, they become one unit. And so when we take Pennsylvania, historically antiquated, we're married, we're taking it entirely as one unit. So it's by the entireties. We are one unit. And that means, that means that you and Kelly own every molecule in the house. You don't own half of every molecule in the house. You each own the whole molecule. It's like your egg is scrambled. You don't, one of you doesn't get the white and the other one gets the yolk. You've got scrambled eggs, man. It's all yellow. So it's the same thing with the house. And the way that works is by the entireties. If one dies, ownership vests in the other by matter of law, by operation of law. You don't have to go record anything. It just happens. You have to show it, when you go to sell it, you have to show the death certificate to prove that the other person died, and that's about it. Similar with joint tenants with rights of survivorship. If you're not married, and you're involved in a romantic relationship, and you want to buy property together, and I want to protect each other, well, you can buy it as joint tenants with rights of survivorship. And the same thing happens when one of you dies, the other one takes ownership of the whole. And that's fine if you understand what it means. We need to compare that to tenants in common. So if we own as tenants, and you and I, Nick, we're not married, we're not dating. You and I, though, could buy a house, and we could take or any other property and choose to take title either as joint tenants with rights of survivorship, which means when
Or
one
in
of us
common.
dies, the other one takes title, or we could take as tenants in common, which means if we own as tenants in common and you don't say anything, that means each person owns 50%. And literally I own half of the molecule and you own the other half. So what that means is if I die first, if you look at an actuarial table, the chances of that are higher. But if you look at our lifestyles, it's probably you going to die first, knowing the way you drive. And so what happens
You've been in
is,
the car with me.
right. So if I would die first and as tenants in common, you would now own the property with my heirs, because tenants in common, that's how it goes. It's not a horizontal ownership interest, it's a vertical ownership interest. Meaning, so meaning that when you do that, and it also means if I get pissed at you and don't want to own the house with you anymore, and I want to really
You could
screw
sell
you
your
over,
half.
it's my house. I can sell my half to whomever I want. I don't have to tell you. Now, there's a saleability issue with that. Who's going to buy that? There are people that do and can. But that's the tenants in common. And what happens if, you've got, boyfriend and girlfriend are buying a house together. They're engaged to be married, but they can't afford it yet. And they can't get the gift approved. So mom and dad decide to help buy the house.
Mhm.
Well, how do you take title in that one with four people? Two are married and two aren't. So you take, Jane and Bob, joint tenants with the right of survivorship, and Helen and Jacob, tenants by the entirety, take title as joint as tenants in common 50-50. So you've got all three. You can have all three types of ownership in one deed, where you have the two couples, children and parents, own it together as tenants in common. Mom and dad are married, they own as tenants by the entirety. The kids are not married, they own it as joint tenants with rights of survivorship. So you can have various layers, and I see it, right? It's not rare. I wouldn't say it's common, but it's certainly not rare that you run into that. What are some other important things to know about it? Well, tenants by the entirety, you each own 100%. JTROS, joint tenants with right of survivorship, you each own 100%. Tenants in common can be by percentage. You and I can own 50-50, we can own 60-40, we can own 70-10. But we cannot, as joint tenants, we can't do joint tenants with the right of survivorship owning it 50-50. You just screwed up the title. Are you joint tenants or are you tenants in common? I can have joint tenants right of survivorship. You and I can own, you and say that you and Kelly aren't married, since you seem to forget when that happened. You guys take title as, or even as the three of us own a property. You take it as tenants by the entirety, as tenants in common with me, and we do it 60-40, right? 60 to you, 40 to me. And if you pass, it's still 60 to Kelly and 40 to me. If I pass, you guys still own the 60%. My son gets the 40, or, so the point being, the joint interest that you own, if it's JTRS, joint tenants with right of survivorship, you each own 100% of it. If it's tenants by the entirety, you own 100% of it.
Yeah.
But you can break up your 100% as a lesser percentage with mine. So, and all of that, and I see that look on your face. I don't see it very often. There's not many times when I get your head spinning like it is right now, and or eyes are glazed over, and you're just.
It's because I don't know how my title's done.
Well, that's easy enough to figure out. We can pull your deed and look at it. It's
Yeah.
public record. You can get that. And if you need me to, give me a call on Monday or give Tammy a call and she'll get it for you. But the real important aspect of this is, and it's important to understand, and realtors miss this, that determination is a legal determination. That is law. That is practicing law, and it gets messed up. I saw a deed that was prepared by Realtor's Title Company. Maybe, I don't even know it was Realtor's Title Company. The realtor brought it to closing. It wasn't my closing. I saw it after the fact, and it was joint tenants in common with right of survivorship. The hell is that?
Uh,
And if the default under the law is tenants in common. So if you screw it up and they want it, and where does that really matter? Well, what if you're in a subsequent marriage, second, third, fourth marriage, and you got kids from a prior marriage? Well, when you die, that makes a big difference. Does it go to your spouse, or does your interest go to your spouse or your kid? And And what if your kid doesn't like your spouse? So
Correct.
that can be a very big deal. And that's, maybe the title company can help you with it. Maybe they can't. Is your title company attorney run, attorney involved, or is there no attorney to be found?
Correct.
So that's and that's just it's critical, right? That's how you're owning the property.
Correct. That matters greatly, especially once you are dealing with, the two topics that we've already talked about. Death, when somebody passes.
How about this
Now,
situation? Husband and wife are under agreement to sell. They're downsizing because they're in their 70s, and they're under contract to buy a small house, and husband dies 2 weeks before settlement. Do we have an issue? Let's assume that widow is intending to go forward with the transactions. Do we have an issue?
okay. How was title taken?
By the entireties,
So
husband and wife.
no, we just need death certificate to show that he died, and we could close.
On both transactions, And now, realtor asks the question, well, we need to get an addendum to change that. From who? Well, we need to take the husband off. So who's going to sign taking him off?
Because it takes both signatures.
Right. So okay, so you're saying that what we need to do is we need to delay the closing for a month until we get and like, well, how else are we going to do this? Simple. Let's get title on the phone. Let's call the underwriter and say,
See
hey,
what they want.
do we need to change, do we need to change title? We don't have a bank. It's a purchase cash transaction.
Yep.
We don't have a lender involved. You probably will get underwriting approval to go, hey, it's by the entireties. All right. Doesn't matter that there's a will. We don't care because it goes directly, and all we need is a death certificate. That's probably what they would say. But again, that's where you pump the brakes, don't slam the brakes.
Yep. God, guys, this was a lot of great information for you. As always, though, it's not legal advice. I think the one thing that you really hit on that I definitely want to continue to drive home is it is truly crucial to be working with a title company that has an attorney on staff, whether it's one that is looking at every single document or one that when something like this comes up gets immediately pulled in. This is why it matters. One, yes, most likely is that attorney going to do it at no cost? Probably not. Are they going to do it cheaper than what you would if you'd have to then go find somebody else that is a real estate attorney to fix what the title company screwed up? Yes, I'm sure it's going to be cheaper. Because they're already looking at it. It's already there. It's going to cost probably a good bit less, not saying that it will or won't, but, I think that's huge, guys. And I think that is one of the biggest things that buyers do not understand. You drive that bus, not your realtor, not your lender. So you need to ask those questions. Is this a title company that has an attorney involved? If not, do they have an attorney that's on retainer? If not, I'm not using it. I don't want to be caught with my pants down.
Yeah, I mean, it's kind of one of the consequences of buying and selling residential real estate in Pennsylvania. Practice has evolved over the last 3 decades or so to divest attorneys from their roles in the residential real estate transaction, rather than bringing them in and letting them facilitate and keep things moving smoothly. And it matters, like everything else, it matters who you choose. You want to, just like when you're thinking about which realtor do I want to hire, you're going to think about their qualifications.
We have that coming up.
Right. You want to think about their skill set. Do they understand the transaction? They understand what I need. Same thing with a lawyer. I mean, look, I've never met anybody that can screw up a transaction more thoroughly than a lawyer that doesn't understand residential real estate. On the other hand, an attorney that really does understand residential real estate can smooth over problems as they arise or before they arise, or stay in the background throughout the entire transaction if they're not needed.
Correct.
A good real estate attorney that understands their client's needs isn't going to inject themselves in the middle of the transaction if it's not the appropriate thing to do. And like I
Correct.
tell my clients and the realtors I work with, look, if I'm involved in the transaction and I'm blowing it up, before you get pissed at me, stop and figure out, why is Woodburn blowing this up? There must be a reason.
Yeah.
Because if I'm blowing it up, there's something that needs to be blown up.
Yeah. Well, as always, Brett, we greatly appreciate you spending the time with us today. And guys, don't forget to like, follow, and share for more great content just like this.